Can you be sued for trying to save the world? Yes. Should you hide under the bed and quit trying to save the world? No. Not if you believe in democracy. Not if you believe that a nation that was founded of the people, for the people, and by the people shall not perish from the earth. Go back and look at the First Amendment. Not unless you're willing to give up what Americans of all people in the world have. Congress shall make no laws respecting the establishment of religion, prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition government for a redress of grievances. When you were back in school civics class, that redress of grievances sounded a little bit archaic. It turns out that the Founding Fathers thought that was the single most important part of the First Amendment. We were the only country that have ever been founded on the idea that government has to let you tell them what to do. They don't have to do what you say, but they have to let you say it. There are conservative groups who do not believe that that right exists. They believe that contract law supersedes the First Amendment and that any intentional interference with a contract is tortious interference and subject to damages. For almost 200 years, the petition clause wasn't questioned in court. And then the 60s came along and all those wild children. And corporations and angry billionaires with deep pockets looked for a tool to silence that advocacy, and they found it. The strategy earned a name. It's called a SLAPP suit with 2 Ps. Strategic lawsuit against public participation. SLAPP suits are not just about environmentalist and raucous youth. In Colorado in the 1980s, a woman was sued because she complained to her school board member when she ran into her in the grocery store about the fact that the school bus brakes screeched. The school bus company sued her. That's a SLAPP suit. Religious groups have been sued for complaining about the curriculum. All over the country, in every state, there have been SLAPP suits trying to make people be quiet. Homeowners groups who complained about zoning have been sued under SLAPP suits. More recently, Resolute Timber Company sued Greenpeace for umpteen $1 billion. And they said that Greenpeace was guilty of tortious interference because they had called Resolute Timber forest destroyers. They put expert witnesses on the stand to say they had not destroyed the entire forest, and therefore it was a malicious lie, and Greenpeace should pay them. That was thrown out of court. The Dakota Pipeline Company sued the Standing Sioux and said that their protests were not protected by the First Amendment. The Riverkeeper, the Delaware Riverkeeper, was sued by a developer for pointing out the harm to the river that might come from the project. In all of those cases, the petitioner, the First Amendment petitioner, won. But SLAPP suits aren't meant to win. According to Wikipedia, in the typical SLAPP suit, the plaintiff does not normally expect to win the lawsuit. The plaintiff's goals are accomplished if the defendant succumbs to fear, intimidation, mounting legal cost, or simple exhaustion, and abandons the criticism. SLAPP suits are to make you shut up. They also try to pick someone that if they can make them shut up, everyone else will shut up. If you want to know more about SLAPP suits, there is a wonderful book that was written by Kanan and Pring called Slapped. You can get it off Amazon, Getting Sued for Speaking Out. It covers 30 years of SLAPP suits around the countries. If you want to laugh at SLAPP suits, just Google John Oliver SLAPP suit. I will say no more, but it's worth watching several times, particularly if you've been slapped. I am currently the poster child for SLAPP suits in the state of Florida. I am being sued by George Lindemann Jr. and a case that is styled Lake Point versus Hurchalla. I lost at the circuit court level, and the DCA affirmed it, and we are now on our way to ask the state Supreme Court for review. This is not the story of a poor little old lady destroyed by a billionaire bully and his snidely whiplash lawyers. I am 79 years old. I am not little, and I am not destroyed. I am awed at the support I've gotten from friends and from people I've never met, and from a legal team that is beyond wonderful. You can read all about it in the Lake Point case at the website slapmaggy.com with 2 P's. Maggie has a Y. And you can read all the legal briefs if you like to at defendmaggy.com. I'm on my way to the Supreme Court, standing in the middle of the road like a possum in the headlights, because of the precedents that this case will set for all of you, for all of us. A friend of the court brief at the appeals court level noted that if the $4.3 million judgment leveled against the appellant is not reversed, most environmental advocacy in Florida will likely cease to exist. What are those new and frightening precedents? Number one, you can be sued for something you did not say. Number two, having a qualified expert that agrees with you is not evidence that you weren't lying. Number three, disagreement between qualified experts indicates one of them was lying. Number four, you have no First Amendment protection if you use improper methods. The court determined that there were certain improper methods used. They included contacting a commissioner outside a public meeting. Number two, attempting to influence commissioners that were your friends. Number three, they said it was very telling that she attempted to influence commissioners who were ignorant about the subject. And being influential. Being influential, they said, was unfair because you might have undue influence, and therefore you shouldn't criticize. Proof of malice in the case was the fact of a signature, a irreverent signature on an email that said, Deep Rock Pit. How does that compare with the existing precedents that you thought you had in the state of Florida? The standard of losing your First Amendment privilege has been clear and convincing evidence with the burden of proof on the person suing you that there was actual and express malice. You lied. You lied knowingly. You lied solely for the purpose of harming the company. To find actual malice, according to the courts, there must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of their public statement. And furthermore, the Florida courts have said that they require extreme, in proof of malice, of express malice, it requires extreme hostility to gratify malevolence and evil intent. The Florida Supreme Court has held that a qualified privilege isn't overcome by the simple fact that the defendant made a statement that wasn't true. Since the adoption of the First Amendment, the courts have allowed boisterous disagreement in the forum of public opinion. That's what democracy is all about. It is not wrong to disagree. That's not tortious interference. Being angry at the opposite side is not tortious interference. Your methods, whether it's waving signs, waving an armband, or making speeches, or calling on the telephone, or talking to someone in the grocery store, are not tortious interference. What is wrong and what is actionable is to malevolently make up lies for the sole purpose of putting a company out of business. Don't do that, no matter what you do. So how do you keep from being sued? Quite honestly, you don't. Vengeful billionaires and deep-pocket corporations will continue to use this strategy against all of you for as long as it works. There are some things you can do. Number one, make your complaint to government. The petition clause is stronger than the free speech clause. Petitioning government means they have to let you say, and then they decide. They don't have to do what you say, but they have to listen. Number two, simply adding, in my opinion, does not save you. that the court held in the ruling at the 4th DCA, in my case, that statements are not privileged opinion where the speaker or the writer neglects to provide the audience with an adequate factual foundation prior to engaging in the offensive discourse. Now try doing that in 3 minutes. Try to imagine doing all of that. Using hyperbole, though, is a savior. If you want to insult somebody you've gotten really mad at in an advocacy argument, be outlandish. Jerry Falwell sued a magazine for running a cartoon showing him losing his virginity to his mother in an outhouse. The courthouse threw that out as hyperbole. If it wasn't actually likely to be true, you're safe. Number 4, you are not legally required to save everything you ever sent to a county commissioner or a public official. But once somebody has threatened to sue you or sue you, do save them all. Number 2, the fact that you obeyed the law as it now stands will not help if you have a bad judicial ruling. The judge in our case at the lower level said that you should expect to be sued if you criticized a billionaire corporation, and therefore you had a duty to preserve anything you ever said about his corporation. On the basis of that, the judge told the jury that they could make an adverse inference that there had been emails that they never saw because they were deleted, and that they could use those emails as evidence. An interesting form of evidence. 6, be aware that your email may be hacked and your phone may be tapped. You are not paranoid. Slappers are not nice people, and they have very deep pockets. Number 7, it is probably not wise to be irreverent. I find that very sad. I like to not take myself too seriously while taking my causes seriously, and I like to think that saving the world is fun. 8, do your homework. Always do your homework and be as accurate as possible. If you do get a threat of a lawsuit and a letter that seems so absolutely ridiculous you're about to throw the letter away, don't throw it away. Sit down with your lawyer and answer it carefully and patiently. It won't keep them from suing you, but it may be useful in the lawsuit. Number 10, get together with your allies, go to meetings en masse. Number 11, some public officials will tell you, if you could just get a representative to speak for all of you that are here wearing those blue armbands. Don't do that. It's we the people. Let everybody speak. Number 12, work with state and national environmental organizations. They can be wonderful help in giving you backup on your research information and your conclusions. Number 13, lobby your legislature for stronger SLAPP suits. Florida has a very strong constitution that encourages citizens to influence their officials. They have a very weak SLAPP suit law. Number 14, and somebody said this earlier today, pay attention to your judicial races. Those local courts are going to make all the difference. They sort of automatically get reelected. If you got a really bad judge, get the Bar Association rating publicized. Find somebody good to run against him or her and get good people elected. They don't have to be on your side. They just have to be intelligent and honest and know the law. Number 15, help others being slapped. I have more than 20 amici, I think, the last time I looked. ACLU and River Keepers and just all sorts of wonderful people. I couldn't do this without them. 16, join Protect the Protesters. Look it up. Protect the Protesters on the website. ACLU, NRDC, Greenpeace, Electronics Frontier Association, Freedom of the Press Association. Make sure all of your friends in advocacy know about the Protect the Protesters group. It's a movement we're going to have nationally if we're going to hold on to what we think we have. Number 17, have parties to watch John Oliver. We have to keep laughing. Number 18, read Canaan and Pring. It's very well written. You'll find it very readable and very useful. Number 19, if you are going to be a troublemaker in the eyes of those with money and power, it is time that you redo your estate planning. Your will and your living will are probably out of date. You want to get a very good lawyer that is very knowledgeable about estate planning. And if you are married, you want to learn the difference between tenants in common and tenants in the entireties. Your bank will claim it doesn't know and that you really want to be tenants in common. That way they can take half your bank account if they have a lien against you. Tenants in the entireties mean that two of you own a single item. and as long as you are both alive, they can't have half of it. I would presume most of us plan to stay together and would rather be in the entirities. And when your depositions are over, when you get to trial, make sure that your whole legal team emphasizes the constitutional issues throughout. Ask for summary judgment on constitutional issues, bring it up in cross-exam, bring it up in opening and closing statement, and all the way through. And finally, the First Amendment's worth it. America's worth it. Hug each other and don't back down. If no one stands up to the big bullies, the little bullies will come out of the woodwork and run the world. Go make a difference.